the Supreme Court delivered a landmark judgment with respect to legalization of same-sex marriage in a case called. One person who definitely got punished for his sexual orientation was Alan Turing. He is a great mathematician. In fact, the Second World War was won by the Allied forces primarily because what is the pros and cons of this, guys? See, why do you need a legislation? Finally, 5 judges in the Constitution bench, by a unanimous judgment, they said we cannot legalize same-sex marriage. It is something which has to be done by the. Hi everyone, welcome. So just about a couple of days ago, the Supreme Court delivered a landmark judgment with respect to legalization of same-sex marriage in a case called Suprio case, where the Supreme Court has declined to pass orders for legalizing the marriage and said it is the Parliament which has to finally make the laws relating to these matters, Parliament and the state legislatures. So in this video, we'll understand the historical background to the criminalization and decriminalization of same-sex relationship, which is also known as homosexuality, and what is the Supreme Court case about, which was decided by the Supreme Court, and what is the way forward. So if you go to the historical background, see, in some of the religions like Hinduism, whether there is any explicit negative or restriction on same-sex relationship. I mean, I'm not an expert in theology, but my understanding based on reading some of the blogs and other things is that there may not be any explicit restriction. Whereas in Abrahamic religions like Christianity and Islam, the religious scriptures specifically say that same-sex relationship is a sin. So these are religious beliefs which guide the people in a society. If you come to it from a historical background, there was this era known as Victorian era. So what is the Victorian era? Queen Victoria. Now she was the longest serving British monarch before Queen Elizabeth. Queen Elizabeth served for 70 years as the Queen. Queen Victoria served from 1837 to 1901, if I'm not wrong, for close to 63 years as the Queen of Britain. And this is the middle of the 19th century. And that era is known as Victorian era. There were a lot of positive outcomes because of that Victorian era. It is also known as Victorian morality, where slavery was sought to be abolished, child labor was sought to be abolished. So all these things were the positive effects of those morality. But also with respect to sexual relationships, there were restrictions on women, on engaging in any sexual relationship before their marriage. They were supposed to have sexual relations only with their husband. And also same-sex relationship was criminalized. There are debates as to whether even King Alexander the Great or even the famous scientist Isaac Newton, whether they had any sexual orientations towards the same sex. But these are all speculations. But one person who definitely got punished for his sexual orientation was Alan Turing. He is a great mathematician. In fact, the Second World War was won by the Allied forces primarily because of his interception of the codes that were sent by the Nazi Germany. In fact, there's a brilliant movie called The Imitation Game. If any of you have not watched it, please watch it. It's a wonderful movie about the life of Alan Turing. But this is the world, experience, so to speak, or the British experience, and it has an influence in the Indian scenario as well. So, in the Indian scenario, Section 377 of the Indian Penal Code, and when was Indian Penal Code enacted? It was enacted in the year 1860. So, some of these provisions of the Indian Penal Code are guided by the Victorian morality during that era. And because same-sex relationship was considered a crime at that point of time in Britain, it was reversed only during the middle of the 20th century in Britain itself. In India, Section 377 of the IPC said same-sex relationship, even amongst consenting adults, is a crime which can be punished with imprisonment up to 7 years. Unnatural sex, as it was termed in Section 377. But then later, in the right to privacy judgment, in fact, the Supreme Court upheld this section in a judgment in 2013 that it is constitutionally valid. But later, right to privacy was declared as a fundamental right in Puttaswamy case. And because of this judgment, in Navtej Singh case in 2018, the Supreme Court struck down Section 377 as unconstitutional. If it is a relationship amongst consenting adults, it is their liberty, it is their right to privacy, and the state should not, the government should not interfere in it. So now, guys, there are different steps. See, world over, same-sex relationship was a crime, right? Because that is what is the religious morality that all religions across the world practiced and continue to practice most of the time. But in a society, in a liberal society, every individual should have their own right, and there is no evidence to show that it is a societal or a cultural practice. It is primarily a genetic disposition. So an individual's sexual orientation should not be a subject matter of criminality in a society. So the first step is to decriminalize, meaning you will not be punished if you have such a sexual orientation. And that has been done in India in the year 2018. But the next step is to legalize, which means you recognize same-sex couples and you give them all the rights which a heterosexual couple means a man and a woman, will have, including right of adoption of children, including all the financial rights of inheritance, succession, nomination, etc. So this case, the Supreo case, and various other petitions which were clubbed along with this case, was actually wanting the Supreme Court to interpret the Special Marriages Act. See, because in India, marriages are governed by the respective religious beliefs, and they are governed by, for Hindus, it is the Hindu Marriage Act. For Muslims, it is the application of Sharia Act. For Christians, there is a Marriage Act relating to Christians. For Parsis, they have their own marriage regulations. Sikhs have the Anand Marriage Act. But people who want to not be governed by any of these religious requirements and want a secular marriage tradition, they can register their marriage under Special Marriage Act. And the plea in front of the Supreme Court in this Supreo case was that you should declare even same-sex couples, their marriage can be registered under the Special Marriage Act. Now, what is the pros and cons of this, guys? See, why do you need a legislation for recognizing same-sex couples? See, because as I told you, the right to life and liberty of every individual, right? And nobody should be discriminated against. It's the right to equality, the right to liberty of an individual. And if they are in a relationship, they may want to have children adopted. They may want to have financial rights in terms of, succession, inheritance of property, nomination in insurance and other banking transactions. And there will also be a social recognition, right? Okay, they are a married couple, even though they belong to the same sex, and society has to recognize them. And the first step is probably to give them a legal recognition. So these are the arguments which were put forth by the lawyers who argued in favor of the Supreme Court giving a declaration to interpret the Special Marriage Act to include the same-sex couples as well. But what was the argument of the government, right, which was against this declaration? Firstly, religious scriptures, religious beliefs are against this. And in India, marriages are governed by the respective religious laws and beliefs. The purpose of marriage is procreation, which is to have children, and same-sex marriages will not be able to do that. More importantly, this is for the legislature, because the legislature is elected by the people, it is representing the people. So they should discuss and debate and formulate a law, if at all, if it is required, when the society is ready. It is not just one act. Any change in interpretation of the Special Marriage Act will have a cascading effect on more than 160 laws which deal with marriage and its matters. And so it is best left to the domain of the legislature, parliament and state legislature. Marriage is a matter under the concurrent list. So even the states have a say in this. So they said it should not be done by the courts. And finally, what did the Supreme Court decide? The Supreme Court, after hearing all this, all the Supreme Court judges were considerate towards the claims and the rights of same-sex couples. But they felt, by a unanimous judgment, 5 judges in the Constitution bench, by a unanimous judgment, they said we cannot legalize same-sex marriage. It is something which has to be done by the parliament and the state legislature. I mean, it is under separation of powers between legislature and judiciary, but still, for enforcement of a fundamental right, we don't have to believe in separation of powers, but they declared that right to marry is not an inherent declared fundamental right, and this has to evolve through a legislation by the parliament and state legislature. By a split verdict of 3:2, in fact, the Chief Justice of India and one more judge were in favor of recognizing civil unions. What is civil unions? It is just short of marriage. There are various countries, there are around 35 countries which recognize same-sex couples and they legally register their marriages. I think 33 or 35 countries across the world. There are few other countries which recognize civil unions, so which gives the same set of rights that a married couple has, except for few rights. So they were actually in favor of recognizing a civil union amongst these same-sex couples, but majority 3 judges said even that is something which we courts cannot do. It has to be done by the legislature. But they all agreed that police and the government should not harass same-sex couples. They should not be discriminated against in public places or in employment or in other places. So that is something which is a kind of an opinion of the Supreme Court. But the primary judgment is, they said we cannot recognize it. It is the legislature domain, which in all fairness, I think is a good judgment, because, there are more, technical and tricky issues which are involved here. It is a classic example of judicial restraint by the judiciary, which said we recognize their needs, but we cannot do it. It is for the legislature to act on it. But what is the way forward, guys? First of all, the government has also, the Solicitor General has confirmed that the government will form a committee to look at these matters, right? Which should be done immediately, and they should get the basic financial and other needs. See, because if you have to give a nominee in a bank account, if you have to give a nominee in the insurance policy, if you have to own a property together, now these are some matters in which the law will recognize only a married couple between a man and a woman. So that is something which has to be done, so that the financial security of the same-sex couples is something which is protected. But there are certain complex issues also here, right? See, because there is something called as Protection of Women from Domestic Violence Act, because domestic violence is a major issue in our country. So the man, if there is violence on the women in a family, right, the woman gets protection. But in a same-sex couple, how does it work, right? So whether two men are married, then whether one of the man will designate himself as the husband and the other man as the wife. So will that mean that the biological male will also be subject to the same protection that a woman gets under the Protection of Women under the Domestic Violence Act? If two women marry, if one is designated as the husband and the other as the wife, will the biological women be subjected to the same punishment that a man is subjected to under the Protection of Women from Domestic Violence Act? These are slightly complex issues. Adoption rights. See, there is no research to say that same-sex couples adopting a children, they will be worse off than heterosexual couple raising a children. There is no research to do that. There are problems in heterosexual families. The same-sex couples may bring up a child even in a better manner. We don't know. There is no scientific evidence or research to show one way or the otherwise. But there is a CARA, which is the adoption authority in India, which has certain regulations. Single male cannot adopt a child. Then how does it affect the adoption rights? So these are some complex issues which the committee has to decide. But guys, see, people say it is not as per societal morality. See, morality changes from person to person, right from the way you dress to your habits. The morality of every individual is different. But in our constitution, in our democratic country, what is important? The word morality is used even in freedom of speech and expression, restrictions, in other places of fundamental rights. But the Supreme Court has time and again reiterated, but morality here does not mean individual morality, which may vary from person to person. It is constitutional morality. And what is constitutional morality's essence? Equality and liberty. So irrespective of the sexual orientation, a person should enjoy equality and no discrimination in the society. They should have the liberty to live their life like any other person. And for that, these matters should be discussed in the committee, and as soon as possible, a law should be made taking all these nuances into account, which give them a dignified life, which is not a favor that the society is doing to them or the country or the state is doing to them, but which they enjoy as a fundamental right of equality and liberty in the country. So I hope you found this video useful. Now, from a UPSC angle, critical analysis of same-sex marriages, right to marry a person of one's choice was declared as part of Article 21 in the Hadia case, and in fact that was asked as a prelims question, in fact, in 2018. But in this judgment, Supreme case, the Supreme Court has said it is not a fundamental right. So, guys, it is all subject from case to case. Anyways, right to marry was not a declared fundamental right like right to privacy. So that is why the Supreme Court has interpreted it this way when it comes to same-sex couples. And this is again a classic example of judicial activism, judicial overreach versus judicial restraint. So they said committee should be formed, right? And they should not be discriminated against. These are all judicial activism. But they did not go for judicial overreach and declared something as legal which they are not competent to do. They exercised judicial restraint and they asked the legislature to legislate on it. So that is a classic example of judicial restraint. Thank you.